Yes.
Please for listing.
Yeah, listing, give it to the court master, please.
That's. Maybe
To give it, they'll have to make some adjustments.
my lord. I beg to mention item number 40, my lord, supplementary list, my lord.
40.
40, my lord. The party, the petition wants to get some other set of advocate, my lord. Sometime
Okay.
maybe allowed, my
Both
lord.
sides are represented on the prayer made by learned counsel for the petitioner. List after 2 weeks.
Oh, bless.
Lordship, I beg to mention item number 20. Today we have some difficulties, so the matter may adjourn for today and may fix any date, Lordship. As Lordship's
Okay.
company,
After how many days you want?
next Friday or a date may be fixed, Lordship.
Okay. Friday will fix, but you'll have to undertake to come and argue the matter on 5th on Friday. Do you undertake?
Oh, no, Lordship.
No.
Friday is holiday.
Okay, list after a week as prayed for by learned counsel for the petitioner.
Of lunch.
Okay.
Maybe I beg to mention item number 7 for pass over.
7. Okay. List after a week as prayed for by learned counsel for the petitioner. Next.
My lord, I beg to mention in respect of item number 4, your lordship. Let the matter be listed for admission hearing, my lord. LCR is also.
No, every day is a hearing day.
My lord,
Any difficulty in hearing the matter now?
my lord. After vacation.
Huh?
After holidays, my lord. After 2 weeks may be taken up.
You
After
wanted
2 weeks.
adjournment, says,
But listed
whether
for
it
motion.
should be admitted or dismissed is for us to decide.
My lord. After 2 weeks.
Okay, just a moment. Item number
4.
4. Just
Four.
give it a minute. Twice it was adjourned on your prayer. Okay, list after 2 weeks as paid for by learned counsel for the petitioner. Next.
Updated item 34 for orders with IA.
Please, your worships, it is for substitution of legal years. As because the petitioner died on 19/9/2021 and as per order 19/4/2022,
But once a
implement is made.
but once a opinion is given, we have to dismiss it. That is the previous orders of the court. No,
In case the person-
legal heads can.
they can be substituted, Lordship, because it
Can
has
we
to
allow
come
the
to its
application?
logical conclusion, Lordship.
Can we allow the application then?
Yes, Lordship.
But Mr. S.C. Pandit, learned counsel for the petitioner. Also heard Ms.
Item
A. Verma, learned
four.
standing counsel for the responding numbers 2 and 3. 2 and 3.
Amir Ali.
2, 3. 2, 3 and 2, 3, 7, 8.
Abdul Ali, Abdul As.
You got instructions on this NRC? Mr.
Lordship.
Sharma?
Lordship, tomorrow I will get.
Okay. For the Union of India,
UK Goswami.
UP Goswami, CC, representing respondent, one, Mr. P. Sharma, learned government advocate, appearing for respondent number 4. And Mr. Kuli, learned counsel, appearing on behalf of Mr. A.I. Ali, standing counsel for respondent number 5. Next paragraph is the standing counsel for the Home Department has not yet received instructions in respect of appearing for respondent number 6. Issuance of notice on the said respondent is dispensed with. As respondent number 6 is a establishment under the state government. Next paragraph. By filing the connected writ petition, Abdul Ali, son of late Johanal Ali, has assailed the
President of Qasim.
opinion dated Nine 1/2020. No, sorry, it is opinion dated 23/2020, passed by the learned member, foreigners tribunal -1, Nalbari in FT within bracket NAL, bracket close, case number within bracket N, bracket close 2882 of 2006. During the pendency of said writ petition, the said writ petitioner has expired on 19/9/2021. Accordingly, by filing this interlocutory application under Order 22 Rule 3 CPC, the petitioner hearing seeks impleadment as a legal representative of the deceased writ petitioner. First of all, the petitioner hearing has given the details of other family members of the deceased in paragraph 2 of this interlocutory application. Next paragraph. As the pair made in this interlocutory application has not been objected to, the said prayer is allowed, prayer for substitution is allowed, and the applicant, namely petitioner, namely Muhammad Abdul Ali, son of late Johanal Ali, is substituted in the place of deceased Johanal Ali, the petitioner in WPC 4818 of 2021. Next one.
Lordship, in place of Abdul Ali. This is Abdul Ali.
Abdul Ali.
Abdul Ali. Amir Ali,
Oh, acha.
Jalekha, Shahjahan,
Okay,
Shah.
the name is different. There's a mistake. Mr. Amir Ali. Names are at page 3. Mohammed Amir Ali, Jaleka Khatun. There are 7 petitioners. They are substituted in place of late Abdul Ali. Mohammed Abdul Ali, MD, first of Abdul Ali. The petitioner in WBC 4818 of 2021. Next paragraph. The petitioners shall furnish a type copy of the cost title of the connected writ petition to the AOJ civil rule within bracket pending section upon which the cost title shall be suitably amended, and thereafter the said writ petition will be registered before the court.
Amended.
You want to file an amended petition? You want to file an amended petition?
Proceed.
You want to file an amended petition?
Now, if required, amended petition will be filed.
But you can't do that. You can't do that.
Lagi bone? Na lagi.
Amended petition you can't file.
And file a fresh.
Yes, that is different. You can't file a,
Substituting the names, Lordship, and.
on substitution, you can't file a fresh writ petition. Yes. Okay. I get this question.
You can put it over ISA. I 3536 same.
Yes, item 35.
May I please, Lord? My Lord, I for extension of time, my Lord. My Lord, I have stated in para 5.
What time is for hearing before the police? When was the order passed?
That was passed on 22/11.
1 year. 22/11, 23,
23.
1 year.
Yeah, within the time.
We can't permit prayer like this.
My Lord,
We can't allow prayer like this.
my Lord, they appeared, my Lord, before the SP for furnishing.
We'll ask for instructions then.
Yes, my Lord, yes.
You get an instruction.
Bucks.
SP marked right.
That was also in 2023.
It's
We
almost
are
a year.
almost a year now.
My Lord, I have stated the ground, my Lord, at para 6 also.
And he's added some medical documents also, Lordship. And after 1 year, Lordship, approaching. the
Yeah, my
court-
Lord submitted, but in the meantime, my Lord, the mother of the SP expired.
But the office doesn't stop, Lordship. Office continues even if there is some bereavement, Lordship.
No, they refused to accept the bail bond, the official.
Lordship,
Oh,
I
you see,
explain
you have a very
instructions.
interesting doctor. You have a very, very interesting doctor. And if you go to doctors like this, definitely the world will be enriched. You will have to share your experience. We will call for a medical day. We will ask your petitioner to come to court and explain explain her experience, his or her experience in court. He has diarrhea, and the doctor advises him PA view of PA X-ray, what you call of chest.
And this prescription is valid only for 28 days. Lordship will look at
No,
the
no,
last slide.
that is very good. But you see, if people go to a doctor for diarrhea, they get a X-ray of chest. Definitely, we'd like to hear
Yes.
him.
Sugar, allergy, profile, Lordship, everything.
No, we understand. Prescription speaks a volume. Wait, statement. There's a statement. He was a para 6 from various disease as well as chronic loose motion. You don't know. Only these things strike our eyes. Everything else may not have. That's right. When you file documents, read it. Otherwise,
I remember during this, when this matter was taken up, we had even sought instructions whether the case is in Baksa or in Borpeta. And after that, only this order was passed. Lordship will look at page 12, paragraph 10. We had sought instructions
no.
because there was a confusion whether the records are in Borpeta or in Baksa, Lordship.
Okay.
It's almost a year now, and
But Mr. S.A. Ahmed, done counsel for the applicant. Respondents, Ms. A. Verma, done at standing counsel for the Home Department. Representing respondent number 1 and no, sorry, the respondent number 3 and 6.
3-6, Lordship.
Mr. P. Sharma, done at government advocate, appearing for respondent number 5. And Mr. Kuli, done at
It was a
counsel appearing on behalf of Mr. A. standing counsel for the respondent number 2. By filing this interrogatory application, the applicant is seeking extension of time to appear before the Superintendent of Police within bracket border, Baksa. Full stop. By order dated 22/11/2023, passed by this court in WPC 6697 of 2023. The petitioner was directed to appear before the Superintendent of Police within bracket border, bracket with Baksa, on or before 6/12/2023. Full stop. It is projected that the applicant appeared before the said authority on the date fixed, but as the mother of the said authority had expired, he had left office on the same day, and for which the bail bond could not be accepted. Next one. Next one. That the standing counsel for the Home Department obtain instructions in respect of the statement made in paragraph 5 of this interlocutory application. You want to file objection also? No.
No, Lordship will just obtain
Instructions.
instructions and place it.
How much time?
1 week, Lordship.
List after a week. That's great.
Extra copies of this I may be served.
Extra copies, please give her. Before that, before list after a week, requisite extra copies of the interlocutory application be provided to the learned standing counsel for the Home Department. Yes.
36.
This is same one. One of the brother of earlier citizen.
Same.
Same.
Same order.
Baksa Niti.
Same order, same date. Okay.
Oblige.
Supply item 42.
From Irubutta planning.
May please, Viva.
Yes.
In this matter, I am seeking certain modification lordship. Your lordship has granted interim bail to me lordship, and thereafter I appear before the SP Border Borpeta lordship. And the SP Border Borpeta informed me that the case records has been transferred to the SP Border Baksa lordship.
Baksa.
Yes, ma'am. So it will be SP Border Baksa. I have to appear before the SP Border Baksa. Order
I
is-
feel wherever there we have this Baksa and Borpeta and a lordship. Lordships and orders can reflect both the SP's name, which wherever the records are.
No,
Earlier we did do
no,
like this.
You'll have to tell us because we at times tend to omit the cause title.
Yes.
So please
In most
indicate
of
it
the
to us.
matters in Borpeta and Baksa lordship, we have seen the
No, we'll do
matters
it.
have been
We'll do
transferred.
it, but we miss out the cause title every time.
They will also have to make respondents to both the SPs, Baksa and Borpeta, both
So
lordships.
just indicate, then we'll
In
pass
this
orders.
case also I have made lordship party both.
You made both,
But
no?
yes, yes.
So when they're both the parties,
Respondent
lordship
number
will
6.
indicate both the names.
Respondent number 6 of the petition will be,
Okay.
and time is
This,
also
this
extended.
interlocutory application we shall allow.
Yes, lordship.
Heard Mr. J. Abbas,
Yes, sir.
learned counsel for the applicant. Respondent counsel is the same.
Yes.
Yes,
Yes.
please.
And maybe for respondent.
Acha, N. Bedi
On behalf of
on behalf of Ms. P. Barwa, standing counsel for Election Commission of India. Okay. By filing this interlocutory applications, the applicant, who is the writ petitioner in the connected WPC 4800 of 2024, is seeking modification, the alteration of the order dated 4/10/2024, passed in WPC 4800 of 2024. Next paragraph. The learned counsel for the applicant has submitted that as a condition of bail, the petitioner, the applicant was directed to appear before the Superintendent of Police within bracket border, bracket was Borpeta, within 17/10/2024, and furnish a bail bond of rupees 5,000 with condition attached thereto. However, it is submitted that as the records have since been transferred from the office of the Superintendent of Police within bracket B, Dr. Borpeta, Q2, the office of the Superintendent of Police within bracket border, bracket Baksa, having jurisdiction over the place of residence of the applicant, it is submitted that his bail bond was not accepted by the Superintendent of Police within bracket border, bracket close, Borpeta. Next paragraph. As the prayer made in this application is not objected to, comma, the application stands allowed. The prayer made in this application stands allowed. First of all, the order dated 4/10/2024, passed in WPC 4800 of 2024, is modified to permit the applicant no, you just say paragraph 5 of the said order, so and so is modified to the extent that the applicant, who is the petitioner in WPC, give the name of the applicant, applicant namely so and so, who is the petitioner in WPC 4800 of 2024. Comma, if not already detained in custody, comma, shall not be taken into custody and deported from the territory of India on the condition that he will appear before the Superintendent of Police within the border, close Baksa, within the extended time of within 14/11/2024, and shall furnish a bail bond of rupees 5,000 with one local surety of like amount to the satisfaction of the said authority. Full stop. On her appearance, on his appearance, you just say on the appearance of the petitioner, comma, the further directions contained in the order dated 4/10/2024, passed in WPC 4800/2020 shall be complied with. Next paragraph, this order shall be read together with order dated 4/10/2024, passed by this court in WPC 4800/2024.
Deeply obliged.
Interrogative application stands disposed of.
Obliged.
43.
May I please?
What did we miss out here?
Here is my lord.
Case
Yep.
number is not given.
Yes, application now not mentioned. Others are.
Mr. Verma, we allow this application. There's a mistake in this order for the second time.
Yes. Unfortunately, no.
Mr. A.M. Amit, the counsel for the applicant. The respondents will be same. Mr. Cooley will be here now for ECI. On behalf of AILE. Next one. Now, FT case number.
Why are the departments so technical? This is they can find out to which case number this order relates to.
If it's a police station, it becomes because the order states one police station lordship.
No, this is foreigners matters.
But
The records are with the Superintendent of Police border. They can, for the small omissions in the order,
number of times we had a word, they say that if it is not written in the order, they're scared to do. They're afraid of the court's orders.
Sometimes it may be left out, but it's a
Yes.
very technical thing. They have the record, they can find out this petition relates to which. They can ask, they can get.
They can call up and ask, but
Advice.
they don't lordship, like we call up and ask them if whether this matter is, the lot of bifurcation has taken place, so matters have shifted from some districts to others, lordship.
okay, just try to explain it to them. There may be some omissions because we pass orders, so many orders, and then at the time of corrections and
Exactly, lordship.
we miss out something
Yes.
at times.
We direct them to file a copy of the petition also.
Hmm.
We file the APR and serve a copy of the petition.
Next, by filing this interlocutory application, the applicant, namely Rabia Khatun alias Rabia Begum, who is the petitioner in WPC 4273 of 2023, has prayed for modification of the order dated 4/10/2024, passed in WPC 4273 of 2023, on the ground that the FT case number is not indicated in the order. Next paragraph. Although the Office of the Superintendent of Police within bracket border Borpeta has the records of the FT cases against the FT case against the applicant, and must also be having the access to the limits standing us to verify the particulars. Don't say although. So omit the word although in the first line. Full stop. Then next, be that as it may, the court is inclined to clarify that the order dated 4/10/2024 passed by this court in WPC 4273 of 2023 was in connection with the opinion dated 19/1/2023 passed by the learned member, Foreigners Tribunal 11th Borpeta, in case number within bracket Borpeta BPT public 11th bracket closed FT 881 of 2026. It should be 2016.
16. Appears 66 only.
In your writ petition, you have written 26.
Miller constated in the
16
inadvertent.
arising out of
Application number.
reference bearing FT case number 357 of 2013.
Correct.
Stop. Next, this order shall be read together with order dated 4/10/2024 passed by this court in WPC 4273 of 2023.
Publish.
Application stands allowed. আমি তো মোশন করবি।
Daily list item 1 for motion.
After some time, the records have not come.
No,
It is
we
oh, it
were-
is with you. Oh, acha, acha.
we were
No, it's
going
okay. Please go through it. You've seen that?
gone through it, Lordship.
But today the petitioner is not there. Gina Arahamis. Ms. Verma, I'm a bit forgetful of in connection with names.
Yes, Lordship.
The advocates for the petitioner is one Jina Ara Ahmed and one Risha Deka, RISHA, Risha Deka.
Yes.
Do you recollect them as regular counsel here?
Our Deka, I think was Mr. Kane Chaudhary's junior.
No, not she. Risha, RISHA, Risha Deka.
No, Lordship.
Don't recollect because I am otherwise also forgetful of names.
I-
Uh,
These names are not
then,
quite familiar to me, Lordship.
then we appoint an amicus curiae in the matter.
And Lordship, this matters may be taken up, they're pending for a very long time.
So that's why we appoint an amicus curiae. There's no representation from the learned counsel for the petitioner. However, all the respondents are represented. Next para, for instance, justice, the court shall issue, the registry shall issue a notice to the petitioner. Namely, Anna ANA Anna Hussein alias Anna ANA Hussein HOSEN take steps in the matter as unrepresented when the matter was called. Full stop. In the notice, it shall be indicated that if the petitioner is unable to engage a counsel of his choice, he can apply for appointment of an amicus curiae. Not amicus curiae, make it legal aid counsel. Next paragraph. Let the notice be made returnable on 2/12/2024. Next paragraph. List on 2/12/2024.
This one.
Item 2,
मुझे कोई दिक्कत नहीं हम नोटिस दिस मैं देरी कर दूँ
Amicus. Yes, yes.
yes
And the answer is, it should not matter with this for illegal now. Most of us are illegal this for-
Now, even formal actually, hearing of for
Authorized.
every day is hearing day. Litigation. Yes.
No.
Of course. Time will be very long.
Exhibit 1, page 15 million.
Ms. Verma,
Yes, Lordship.
uh, in respect of exhibit 1, which is a Gaon Panchayat certificate, uh, according to you, which document the petitioner went to exhibit? Exhibit 1,
One, that is the only linkage.
that is the
linkage
linkage.
document, Lordship.
Which page is that document?
15, 1/5.
1/5. Now look at the cross-examination.
Page 70.
Page number
Page 73, cross again.
70.
3. PW.
The vernacular is at page 75, I think.
74. 74. Handed.
The relevant part is 75.
There is vernacular, but English is given. No, not vernacular, handwritten. Not vernacular, it is
Handwritten,
handwritten.
Lordship, yes.
Now, I'm good in giving horrible examples. I'm just giving you one.
Yes, Lordship.
Now, we ask you, have you sent the letter to the X seeking instructions? And you tell us I have written. And you show us your office copy. Now, in the office copy, we don't find your signature. We don't find the issue number. And for that, can we,
Accept the
Uh,
document.
no, can we admonish you?
Yes, Lordship. If there is no signature, seal, no
In the office copy.
authenticity,
In the office copy?
but in the absence of an seal and signature, Lordship, can
You
it be
see,
taken?
No, you see, we have not called for the letter copy of the letter from the office of the Superintendent of Police.
Yes, Lordship.
Your office copy is your office copy. Nobody went there to prove that document. So this Gram Panchayat certificate, the petitioner went to the tribunal, proved the document which has the photograph, which has the issue number, has the seal. Now in the
Yes.
office copy, if it is not maintained, can the original go back? Can we held that the original is bad?
Lordship, it has to be compared with the original because there are discrepancies. What has been issued and what has been placed before the tribunal has to be looked into, Lordship.
No, then you see,
This is especially in these matters, Lordship, because most of the times the documents which are placed before the tribunal and the documents which the authorities have issued have lot of discrepancies.
no, you see,
Hmm.
you see,
And
nobody took,
Lordship will see government of Assam cannot be written on these documents. At page 15, the Gaon Panchayat's office of the secretary does not has the power to write government of Assam. We have many
he's a
citations.
government servant, he's a government servant.
Circle officer.
No, he's not a circle officer.
Circle
Circle
officer
officer is
counter
not
He's a
signed.
secretary,
Secretary.
secretary is a government official.
Government.
Judgment would require, yeah.
State gives salary to him.
I'm just trying to find out whether this was issued during the NRC period, Lordship. Because
No,
the
here is the original one.
because Lordship
It-
has the original, because here the Xerox copy is covered, Lordship.
Yes.
If it is during that period, Lordship, then this document has no validity.
No, we'll tell you, we are asking you because we are also in the meanwhile circumspecting what we do. You see, in the order which are typed by the court,
Yes, Lordship.
it is in a, you see, this is the order which we type it in our order sheet. Now, when you get a certified copy, you get it from our online system from where they pick up the cost title. All the other things are done. The signature of comparing assistant and all those are affixed. And then the certified copies are issued.
Monogram is there, Lordship.
No, I am not on that. But you see, the original format does not have what the certified copy contains.
Exactly, Lordship.
Now the question is, the certified copy must be the true replication of what is
has
there in
been-
the original.
Yes, Lordship.
But then there's a mismatch. Because we have developed a system where we don't file, where we don't type all these order sheets.
Mhm.
Because then, supposing in a case there are 80 respondents and there are 20 orders passed from the beginning of the writ petition, the order sheet itself will go to thousands, hundreds of pages. So it will be inconvenient. So we have developed a system where if somebody will ask in the cross-examination, you see, what would be the appropriate question? The appropriate question would be that the appropriate answer would be on that question would be, is it in accordance with the prescription of the High Court? Then the authority will say that yes, because we issue it under the 3.0 CI system, where this is a integrated part of the order. In Supreme Court also, the orders passed are given copies by the court master,
Yes, Lordship.
and the original will always have the signature of the honorable judge. But in certified copies, you get the signature of court master. They give an extract of the proceedings of the court. So for that, the certified copy cannot be questioned. Here you see that the document,
Yes,
it contains signature seal on the photograph, and that is the petitioner has brought.
on this, Lordship, and I'll just read out a paragraph from a order which I have in hand, Lordship. It is exactly on this Gaon Panchayat certificate, Lordship. This and this. How this court has earlier taken these certificates, Lordship.
Yes,
It
yes.
is a order of 2016. Lordship, it says Exhibit D is a certificate dated 15/6/2015 issued by the Secretary Goirabari Gaon Panchayat certifying that Khudeja Khatun was the daughter of Jonab Ali. At the top of the certificate, Government of Assam was prominently printed. It was also mentioned in the certificate that the same was issued on the basis of evidence placed before the Secretary Lordship. Firstly, this document does not appear to be a genuine document in as much as a Gaon Panchayat is not a department of the Government of Assam. Therefore, Gaon Panchayat is not authorized to use a letterhead with Government of Assam printed therein. Secondly, the Secretary of the Gaon Panchayat did not testify before the tribunal, along with the evidence on the basis of which Exhibit D certificate was issued to prove the certificate as well as the contents thereof. Therefore, the certificate was not proved. Thirdly, Supreme Court has clarified in Rupajan Begum, reported in so-and-so, that such a certificate of the Gaon Panchayat Secretary is by no means proof of citizenship. Such a certificate has to be verified at 2 stages. At the first stage, authenticity of the certificate itself is required to be verified to find out to whether it is genuine or not. The second stage of verification relates to verification of the contents. There is nothing on record to show that Exhibit D had undergone any such verification exercise. Therefore, this cannot be accepted as a valid piece of evidence. It is on the basis of the same certificate that we have hundreds of such orders passed, Lordship. Maybe more than that. And further, Lordship, it goes at this stage, we may mention that the learned counsel for the petitioner had argued that the petitioner had submitted an application dated so-and-so to the tribunal to summon the Gaon Bura, school authorities and Gaon Panchayat secretary to prove the above documents, but no summons were issued. We need to clarify that in a proceeding before the foreigners tribunal, burden is on the proceedee to prove his documents. This is made clear by Section 9 of the Foreigners Act 1946, which has got overriding effect over the provisions of the Indian Evidence Act 1872. Therefore, if the proceedee wishes to rely on certain documents, it is he who has to prove the said documents in accordance with law. Insofar the present case is concerned, it was the responsibility of the petitioner to have ensured the presence of the Gaon Bura, headmaster, Gaon Panchayat secretary before the tribunal to prove the above exhibits. Petitioner ought to have given notice to the above persons, and if such persons did not respond to such notice, in such a case, the petitioner would have been justified in filing the above application before the tribunal to summon the above persons. Lordship, if Lordship wishes, I can cite the case, Lordship. It is case number WPC 7756 of 2016. Decided on 26/4/2018.
What is the party name?
Our party's name is Khudeja Khatun. Khudeja.
Can I have the records, please?
Yes, Lordship. Discrepancies and voters list the name first time 2006 or 16 or Aisha. Discrepancies. Voters list. Document issue policy, certificate will be issued policy. This is 2017 of issue policy. One, member issue. During issue policy, he or her. Then now, I receive no belly. Receive no belly. After verification certificate, will be submitted to the GA. Did they verify the application certificate? When the document be updated to LOC, completed certificate, you know the document should verify to run. Some documents be placed before the ground runner, but the certificate will be placed before the certificate. Nothing. Nothing. Back again, documents which is nice on resolution. Issued by the secretary. Novel testimony. Like. Issued by the then secretary. And after verification, issue. EAD may like where we do compare the other genuine documents.
My lord, in this case, my lord, Gaon Panchayat certificate is, my lord, duly proved by the issuing authority, my lord. As per Rupjan Begum, my lord, there is a two types, contents of the certificate and genuineness of the certificate, my lord. In this case, my lord, the secretary of the concerned Gaon Panchayat, my lord, he has reduced and proved the contents and the genuineness of the certificate, my lord, a state respondent did not rebutted, my lord. And all the evidence, my lord, state has not rebutted the evidence, my lord. Even, my lord, DW3, DW5 and DW6, my lord, there is no any finding, my lord. DW3, DW5 and DW6. There is no any finding in the order, my lord.
You said it was proved as per which judgment?
Rupjan Begum, my lord, just assignment, my lord. The contents of the certificate and, my lord, genuineness of the certificate.
But the tribunal made a discussion, that is why, that is on which Ms. Verma is relying on.
Hmm.
The discussion was that it was rejected on the ground that the original office copy
Yeah.
was in variation with
Office
the,
copy, my lord, that is part of the respondent authority, my lord, issuing authority, my lord. Is the petitioner is responsible, my lord? They did not put their
Exactly,
signature
Lordship, this
seal in
is-
the counter folio, my lord.
okay.
Wrong done by the others, my lord. Let the matter be listed for admission, my lord.
No, Lordship.
No, we are hearing it.
Take up this matter.
We are hearing it.
already On it, Lordship.
And, my lord, in this case, my lord, DW3, DW5 and DW6, my lord, there is no any observation in the order.
Apart from the linkage.
Just let him complete. Let
Yes.
Mr. Ahmed complete.
And, my lord, in this case, my lord, initial inquiry, my lord. Initial inquiry, my lord, are referred by the SP directed to his junior officer to conduct the inquiry against the petitioner, my lord. Whereas there is no any iota, any evidence of suspect and source of suspect, my lord. As per Abdul Rahim's case, my lord, related judgment, my lord. There must be
Abdul?
source, my lord. Abdul Rahim, my lord.
What is the judgment, Abdul Rahim?
Abdul Rahim, motion of the man can even go for example.
Into Abdul Rahim to retrospective. Retrospective, no.
Abdul Rahim,
Yes. Recent judgment of Supreme Court.
what is the citation?
Citation, my lord. That's why I am praying. Matter may be fixed for admission, my lord. I am arguing that on this point, my lord. And in this case, my lord, as per Abdul Khalik, my lord, evidence of the petitioner and the others, my lord, did not controverted, did not rebutted by the state authority. Even, my lord, the state has not adduced any evidence, my lord. The state did not adduce any evidence or any witness, nor exhibited any documents, my lord. Page 83, para 4.
Page 83.
Page 83, para 4 last. The OP adduced the evidence of 5 witnesses, including herself, and exhibited 13 number document. The state did not adduce the evidence or any witness, nor exhibited any documents. The state did not prove the inquiry report, my lord. Authenticity of the inquiry report, state did not prove, my lord.
That is settled long back. The government is not required to prove it. It is really an inquiry. In section 9, burden would lie on you. Abdul Rahim is a judgment of this court or Supreme Court?
Supreme Court. The 11th July 2024.
11th,
11th July 2024.
11 July 24.
Yes, না আপনার কাছে যদি ডিভিশন কিছু নাই টেডিও itu থাম আব্দুল রহিম উপর ডিসকাশন হয়েছে ক্যান
Okay. 2024 0 INSC 511.
2024 Lordship, can please repeat it once more?
INSC INSC we have that independent citation 2024 0 INSC 511 decided on 11/7/2024.
Petition the diary number 20674.
You have the
Of 2017.
take out.
It is still diary number 20674 of 2017 decided on 11/7/2024.
Para 32, 33.
Abdul, কি করলো? Lordship, as far as I can remember, there were no specific directions in this order. And this order will have to be taken, it doesn't specify whether it is from prospective effect or retrospective effect, Lordship.
2024 0 SC 575. 0 Supreme.
Group would be just number group. Print out. না মই লুজ আকৌ পাহৰি যাম
First, Mohammed Abu Rahim Ali. না, ঠিক আছে। Volume 0 হবে। Yes, paragraph number? Paragraph number
34, 35 million.
34,
And
35.
in this case, my lord, in the notice, my lord, there is no ground, my lord, as per paragraph 27 million. The ground of the allegation must be charged with the proceeding. As per paragraph 27.
Investigation of history inquiry for documents may be filed. They don't show documents, they don't give us documents, we give them the truth for the court.
Yes. Yes.
In paragraph 27 also, my lord. That
Yes.
in this case, my lord, initial inquiry, my lord, conducted behind back of the petitioner, my lord. And the suspect arrests, my lord, in this case, my lord, SP has no any documents, my lord. Or SP directed to his junior officer to conduct inquiry without any source of suspect, my lord, source of any information, my lord. And ask the petitioner to produce the any documents. State has the power, state get the power under section 9 of the Foreigner Settlement Act. And my lord, go to the door to the proceeding, my lord, ask to produce some documents and later is the inquiry.
Okay.
You can leave it.
And para 36 will plan is. And In the inquiry report, my lord, petitioner address written in Bangladesh, my lord. Kailakus, PS, Pakar district, Dhaka, Bangladesh. I don't know where this address is found on.
Exhaustive. Central government notification to come to Varshavia.
My lord, in this case, the tribunal did not give any finding, my lord, on the DW
Rebuttal against.
DW 356, my lord.
Pardon me?
DW 5 and 6.
3 is that Gambura. Ms. Verma, we have got the STC citation also.
Yes, Lord.
2024,
Yes,
2024 STC online.
I'll just take it on Lordship.
Hmm.
2024,
SCC online.
yes, Lordship.
SC 1695.
SC 1395,
16
1695.
1695.
Yes, Lordship.
We'll take a short break and come back. Ms. Verma, before you begin, we'd like to
Yes.
show you something.
Yes, Lordship.
The first flag and the last flag. Mr. Das. In the last flag, see the last line handwritten.
Yes.
So he was asked to call for the original records. correct?
Yes, bring.
So therefore, the finding of the tribunal is correct. But the fact is that in the order sheet, it is not recorded what was, who had come as deposed as a PW4 and what documents he had brought in.
I think it is there, Lordship. It says that no document.
It is in the opinion,
It's in the opinion, yes.
but where is the order sheet? In the order sheet, if we see, the presence of PW4 is not even recorded.
3 is there because 3 is circle officer. By mistake, he was summoned instead of the election officer.
No,
Yes.
that's okay.
Yes.
His evidence is also there.
Now, the Panchayat Secretary's presence is
We are
not
on 4.
recorded.
3
Yes.
was examined on same day, 1710. His evidence is third flag. After the third flag, the second document is the examination of OPW 3.
There's no mention about the Panchayat Secretary at all.
No.
No.
And what documents were brought is also not there.
Okay, sorry. 17th October, Lordship. Yes, his deposition was taken on 17th.
1710 is PW4.
Yes,
Next page is PW3.
yes, Lordship.
His presence is recorded. PW4 is not recorded. What documents were brought is not recorded.
And his signature is there, but
No, everything is okay, but
Yes.
the presence is not recorded in the order sheet.
order sheet not recorded. 8, 9. Yeah, 9. No mention about.
See, as a writ of certiorari, we are also looking at the records
Yes,
to
Lord.
see if everything is there. But if PW4 is not even recorded,
Maybe Lordship by error because other documents are there. If there had to be some something wrong, then these
no,
depositions would also have been
should
missing.
know. You see, as a matter of record, since we are dealing with evidence now, I'm borrowing something which my past experience is following me. You see, let us say that a document which X has produced before the court is a forged document. Now, please tell us, can the court look at the document and say it is forged? So what happens is that the document which is produced before the court must be mentioned in the order sheet and it has to be exhibited. And then we will say, let us say a Jamabandi is produced, which is a fake Jamabandi. Then what do? I will say that exhibit 1 is the Jamabandi certified copy of Jamabandi proved by PW1 and the original record brought by the circle officer is exhibit 2, and then I impound the document or keep a document true copy thereof on record as 2 by 1 and then send it for forensic examination.
I understand, Lordship, but I fail to understand this missing link, why it is not mentioned in the order sheet. And
It's a lapse on part of the tribunal.
that's also another thing. Even in the opinion, it is very clear that on the basis of some documents, that certificate was issued, Panchayat certificate.
But in the
was
order sheet,
issued.
it should have been recorded that he is present and record and has brought the records. At least then the records would have been.
And the person who issued the certificate did not appear. The in charge appeared. Somebody else appeared,
No,
not
that
the
is okay.
secretary who had issued that certificate.
No, because he is no longer the secretary.
He's no longer.
And people will not be following a retired person or a transferred person.
But in contempt matters, it's different, Lordship. If it is by name, then the contempt.
Then it's okay.
Yes.
But this is not that proceeding.
Hmm.
So if somebody is in charge,
And this certificate was issued in October. This in charge joined only on 8/8 of the same month, 2 months before. And prior to me, so and so,
no, you
the
see, the state
certificate
does not.
was issued. I have been reading this again and again to see what documents were placed before. When the documents placed were legacy
You see,
data.
for that, the objection as to the examination of witness must be made by the state. State
Yes,
should
Lord.
say that A has come to depose, he is not the author of the document, therefore I have objection.
On the rebuttal part, Lordship, there is a citation which we rely on mostly,
Yes,
Lordship.
yes.
The rebuttal evidence by the state before the FT. I will just read that, Lordship. That is on the rebuttal, Lordship. On the other, this was in case filed by the state, Lordship. It was taken up in the year 2017. WPC 2641 of 2017, State of Assam versus Ohabali. OBOHABALI. And paragraph 16 here, Lordship. On the other hand, from the impugned order, we find that after narrating the case as projected by the respondent, tribunal observed that the state did not examine any witnesses and failed to adduce any rebuttal evidence. Therefore, tribunal answered the reference against the state. We are afraid the approach taken by the tribunal is contrary to the law laid down by the full bench of this court in State of Assam versus Muslim Mandal under Section 9 of the Foreigners Act. Burden is on the proceedee to prove that she is not a foreigner, but a citizen of India, and this burden never shifts. This burden has to be discharged by the proceedee by adducing evidence which are admissible, which must be proved, and which must have relevance to the facts in issue. By mere filing of documents without examining its admissibility and without the documents being proved or without examining its relevance, it cannot be said that the proceedee had discharged his burden. Question of rebuttal evidence by the state will arise only if the proceedee adduces evidence which are admissible, proved, and which have relevance. So far as my friend says that there were no rebuttal, Lordship, so only if the evidence produced before the tribunal are admissible, proved, or which have relevance, those would be rebutted, Lordship.
Something is wrong.
Hmm?
Something is wrong.
Hmm.
That's very big thing. Maybe I don't think that's required. Patient or something.
What's the report?
It is illegal. That was what he said.
That was paragraph
Paragraph 16, Lordship.
15,
16,
16.
1-6. On rebuttal evidence. And even in the WS, Lordship,
Anything in reply, Mr. Amir?
But in the rebuttal part, my learned friend, they publicly, I am relying on judgment, Abdul Khalik.
Abdul Khalik. What is the citation?
Little louder.
What is the citation?
As citation Miller, I will provide tomorrow Miller.
Okay, give to the court master.
Yes.
Abdul Khalik.
Yes. Abdul Khalik versus Union of England.
That is by Supreme Court or by High Court?
High Court Miller.
Can you tell us the year?
Most probably 2016 Miller.
On what is the on what point are you relying on this?
Yes, a case is late, my lord. A petitioner side adduced evidence, my lord. State did not rebutted the same, my lord, and accordingly admissible as per Abdul Khalik judgment. And in this case
Okay,
also.
we are not getting it. You just give the citation.
Yes, I am. good.
Okay.
Yes. In this case also, my lord, state silent, keep silent. my lord.
But give it by tomorrow morning.
Yes, yes. Good. And with regard to inquiry Miller, as per Abdul Rahim Miller, paragraph 36, 37, 38, 39, 40 is most important. 34,
Yes.
35, 36, 37, 38, 39, 40. Most
Okay.
important.
Lordship, in reply to his paragraph 34, 35, 36, Lordship, our stand would be that the process of inquiry, Lordship, at that point of time was initiated as per the IMDT Act, Lordship. And where the inquiry prior to reference was an exhaustive process, and that procedure was followed. The section 8 of the IMDT Act, Lordship, 1983 provided that the central government may refer a matter to the tribunal for its decision as to whether the person whose name and other particulars are given in the application is or not an illegal migrant, Lordship. Section 8 at that point of time in the IMDT Act provided that such application shall be made in a form with an affidavit along with so and so. The IMDT tribunal rules had the provision of preliminary inquiry under Rule 3. And the Rule 4, 5, 6, 7, and 8 gives the detailed process of inquiry prior to reference, Lordship. The SP, Lordship, followed the same procedure, and my friend saying that the SP has delegated the process of inquiry to his junior Lordship. On that also, I would like to just state,
Give me this.
when this judgment of Rahim Ali was passed, Lordship,
Rahim Ali.
yes, the
What is-
judgment which Lordship had just stated to 2024 SCC online, Lordship. While passing that judgment, Lordship, the historical background of the issue of foreigners in Assam was not exactly looked into by the court, Lordship. The various legislations like we follow here, Lordship, the Immigrants Expulsion Act, Foreigners Tribunal Order, and the IMDT Act, these were not properly gone into by in that hearing, Lordship. The inclusion of Section 6A in the Citizenship Act by Citizenship Amendment Act 1985 and the landmark decision of Sarbananda Sonowal, Lordship, shows that the state of Assam was always under a threat of
You are-
external aggression.
You are entitled to file a proceeding questioning this judgment.
No, Lordship, that we would be doing, but now since my
But
friend,
assuming it is an obiter according to the submission, then also it is binding.
yes,
Not only the ratio, even the obiter is binding on the high courts.
yes, Lordship.
So the only ground is that you want to distinguish it on facts, if
Yes.
at all. That on these facts, the facts of Rahim Ali and facts of this case are entirely different. Therefore, Rahim Ali doesn't apply.
Not exactly, Lordship.
But the findings in para 35 onwards are binding,
Yes.
notwithstanding what may have been said in the earlier judgments.
And another thing, Lordship, Rahim Ali has no specific directions. It is just a judgment. No directions that the state ought to do this, that nothing is there.
No direction, but
No directions.
there is some finding in those paragraphs. Some observation in those paragraphs.
It is just a statement or the view of the judge's Lordship.
You are entitled to submit. We don't have the liberty to say so. But on facts, you are entitled to say that if you can trace out the facts of Rahim Ali, to say
Yes.
that these facts are different from the present proceeding. You may
Lordship,
submit accordingly.
we'll do that, Lordship.
Both are Nalbari.
No, and this was also, Rahim Ali was also from Nalbari and.
Nalbari, this case also Nalbari.
Yes, yes. I'm not
Other
happy
than
to
the,
that.
other than the district.
Yes, other than the district department. Same district, same SP.
And apart from the linkage certificate, other documents also do not help him, Lordship. Neither the voters list help him.
At least me give any fine.
Just let her complete, let her complete. Don't,
The voters
interrupt.
list has a huge variation of discrepancies, Lordship. We've gone through the complete thing. The names appear only properly in 2016, not before that, Lordship. And his
Something-
only good document before this court is the Panchayat certificate, and which has not been proved as per Rupajan Begum, Lordship. No other document helps him, Lordship. Rahim Ali, আপোনাৰ কাৰণে, মোৰ কাৰণে নহয়। মোৰ কাৰণে নহয়, আপুনি চাওক।
Send you the records once again.
Yes, Lordship.
We'll just put a different fact.
Interestingly, Lordship, Rahim Ali passed away 2 years back and the matter was decided and the court was not made aware of that issue also. Only after the judgment was, had gone viral, we started searching, we found that the proceeding had died 2 years before, which the councils knew and never placed it before the court. Lordship, which,
The
green?
different flag.
Green.
Ah. This is not a reference under IMDT Act, but it's a reference under the new Act. 2010 reference.
2010, Lordship.
So therefore, the provisions of IMDT Act will not apply.
Yes, Lordship. Lordship, another thing I would like to state is when we are talking about the inquiry. Yes, it is a random inquiry. Whoever is doubted, police go to them, they ask them, produce your documents. If no documents are produced, then the police is not supposed to get into their history to take out the documents. Whatever is produced, whatever name, address is given, only that would reflect in the inquiry report. So it is too late in the day for my friend to go back and say that the inquiry was not done properly or the police forced it and there was no inquiry done. In other matters also, we have seen the forms are almost nil because no information is provided about the siblings, the parents. It is just a name and some villages there. And when the reference is before the tribunal, then it is found out that the place where they entered Assam is Dhubri and the proceedings are taking place somewhere in Hojai. Over the years, they have traveled to all the districts, Lordship, and then the transfer matter comes. This document is not from this place. My voters list is from there. My shifting comes. Everything falls into place, Lordship. If we look at it properly, the dots begin to join then.
You see, Ms. Verma, you'll have to overhaul your system. Can you come to page 61
Of the petition, Lordship?
of the petition? See paragraph 19. That is the part of written statement.
Yes.
Now, there is not even a single cross-examination of PW1. The records are with you. Look at the cross-examination of PW1.
Over the years, Lordship, these petitions have improved a lot, Lordship.
And no, that's okay. But if you have to believe this writ petition, come to page 63. Type copies at page 62.
Yes, Lordship.
Now, this is something statement of the witness to
Clarify.
the court. This would mean that there was no cross-examination of PW1.
In a WS, there's no mention about the brother who has appeared in
So
evidence,
that's
Lordship.
okay. Everything may be there. But once you make a statement that they don't say anything, but once they said that, then there's no cross-examination.
There are lapses, Lordship. It is not that.
So you have to overhaul your system first.
Our system.
Although the burden of section 9 is not on us, but we end up reading everything.
I know, Lordship. The more we read, Lordship, the more we can see.
Okay.
Yeah.
Yes, Miller. One page left out, Miller. Two more I have.
And Mr. P. Sharma, the government advocate, appearing for respondent number 3, and Mr. A. Ali, standing for the Election Commission of India, representing respondent number 4, are concluded. Next paragraph. Although the respondent number 5 is a integral part of the establishment of the Home Department of the state, but the State Council has no instructions to appear for the same. So for the said respondent. Next paragraph. The arguments are, the submissions are concluded. The judgment is out.
Complies.
Item number?
মই তাৰমানে কি আছে তেওঁ ক'ব আপুনি সেইটো নাম চেঞ্জ কৰিবলৈ মেম' এপিয়াৰেঞ্চ দিব লাগিব এটা
Complies.
Item 3,
May I plead your lordship? Lordship, in this case, the petitioner declared foreigner post of 71. The petitioner submits the voter list of 1965 father, 1970 father, mother, and Javamuntu copy as well as the link document Gabro certificate. Gabro has come as deposed my lord. The landed tribal did not believe that all the documents were. You too?
DW3,
Elder brother.
elder brother.
Yes, my lord.
Is it not very strange that the name of the uncle and aunt is not known by elder brother? That means the witnesses, they don't even know the family. Therefore, the opinion is correct. What is wrong with the opinion then?
Opinion, my lord, my father name has been appeared in the Brutal Act of 1965. My lord,
Names and the father's name do not match.
house name will be changed, my lord. 1 year, 2 years after, my lord. It should be changed. The village is same. District is same.
You see, you are changing the name as per the document. At one point of time, you come and say that your father's name is different, Ali Hussein.
Ali Hussein and Hussein Ali, my lord. Ali Hussein and Hussein Ali.
No. See page 28, paragraph 7. Actual name of father of EP is Ali Hussein, but in the voters list, there was entered as Hussein Ali.
Hussein Ali, yes, my lord. That will be mentioned in the WS also. Ali Hussein and Hussein Ali same and one person.
No, but you see, there are a lot of judgments of this court where it says that by verbal oral evidence, name cannot be corrected.
But the discrimination of the name, my lord.
Self-explanatory, declaration is no evidence at all.
No, the voter list is prepared by the election office, my lord.
No, that has already been dealt with. You see, you are repeating something which is well settled by this court. Since I think 2018, the same judgment is being followed, repeated everywhere. See, in one voter list, it could be different, but in the other, you'll have to rectify it.
Yes. Only one voter list. Only voter list of 1965, my lord. Hussein Ali. Other is Ali Hussein.
When did you appear? When did your name appear for the first time?
1985, 89. This way.
Page.
This 20. Examine, my lord. This 20.
Showing the name of.
Okay. In the meantime, you go through the records, we'll take it up at 2 again. Continue at 2. Yes. Yes. Mr. Sharma?
Lordship.
Indicates.
The fact that Harmud Ali was son of Nadu Mia has been already duly proved by the aforesaid voter list 1970 and 65, genuineness of which has not been questioned by the state. Thus, non-explanation of relationship of the petitioner with other person mentioned in the voter list cannot be ground for disbelieving the correctness of the entry of the names of the grandparents in the voter list. When the correctness of the entry of the names of the petitioner's father and grandfather is not questioned, thus the plea of the petitioner that his father Hamruz Ali was a son of stands proof. What is thereafter required is to prove whether Hamruz Ali was the father of the petitioner, which our view was also proved, as will be discussed hereinafter.
Relying on any other case laws?
If,
Mr. Bora,
Lordship, for now, Lordship, any other case laws regarding these facts? Lordship?
no, whatever, on merit, whatever you want to rely on, it's not a question of as of now or as of, we are hearing the matter.
Yes. Lordship, my case is that the whole opinion is given on a presumption. And not at para 25 also, it says that non-mentioning of any other relative's name in the voter list of cannot be a ground to disregard that the name of the father. Therefore, Lordship, it is clearly established that Abdul Khalek is the father. Only mistake during cross-examination which the petitioner did was she wrongly spelled the name of Lal Mia as Lal Mahmud, Lordship. Other names also she spelled correctly that, and the whole thing is presumed, Lordship. The state has also not laid any evidence regarding this fact, neither has disputed. Therefore, only because I have not wrongly spelled the name of Lal Mahmud as Lal Mia, Lordship, I humbly submit that cannot be ground to hold that I am not an Indian citizen.
Have you annexed a written statement? No.
Lordship, that only I was searching a written statement. I have not annexed, Lordship. I can bring it by an additional.
No, no, we have the records. It's not required.
Oh. Itu sahabatnya kan di sana he kan itu. Duita ekelenge same common utensils. Common utensils. Lordship, para 25 also page 30. Lordship, page 30, para 25 of the judgments also. It says if the petitioner is able to prove on a basis of reliable and cogent evidence that petitioner is a son of so and so.
Impulsive storyteller, therefore I am just telling you a story. Long back, somebody introduced himself to be, when I was also there, somebody introduced himself to be a lawyer of the High Court. I just asked him how many courtrooms are there. And then he said that, well, I know the High Court is there, but how many rooms? Rooms will be, there will be plenty of rooms. And I mean, courtrooms, how many are there? Then he says again, courtrooms, I have never counted, but I am a High Court lawyer. So that was his statement. I still remember he's a good friend of mine, but that is the statement given. I'm just thinking, now if somebody has to draw a presumption as to whether the said lawyer had a very good practice in Guwahati High Court, what would you say? This is a small story. Presumption we are saying. You see, family members, you give a wrong name. That is something which is not unlikely to happen. Because you see, we are not only looking at this in the perspective of the decision which you have cited, but also in perspective of the observations made in this case of Sarvanand Sonowal. One, those are the parameters which the Supreme Court has examined. You see, when you are relying on this judgment, come to paragraph, page 34. Page 34, you see, last line is a discussion. We are not going on those earlier discussions. These are on 313 and all. Page 34, it starts. 35, it continues. Decision of Ibrahimuddin is referred to. And then half page below, 85.16.
Yes.
The courts below had wrongly drawn adverse inference against the appellant defendant for not producing a document, as there was no specific direction of the court to produce the same. Neither respondent number one plaintiff had ever made application in this regard, nor he filed any application under Order 11 CPC submitting any interrogation for inspection and production of documents. So you see, then the discussion. Now, the court in the last paragraph, page paragraph 36, says that the principle cannot be made applicable in the present case as the facts which the petitioner is alleged to have not disclosed in the written statement subsequent discourse in the cross-examination cannot be said to be adverse or incriminating to the claim of the petitioner, for the reason that existence of other relatives of the petitioner, that his father, does not in any way impeach upon the credibility of his statement. That is the finding of fact. Now please tell me, I've just now given you a story. So if that story in the cross-examination is not sustained, the question was, what will be your presumption as to the nature of practice of the learned lawyer? It doesn't impeach the credibility of the lawyer, but it's a question of where he practices. Because if he's practicing in a high court and does not know the courtrooms, will be a presumption against him. Now the fact is that Ibrahimuddin was decided on the principles of Order 21 Rule 27, 41 Rule 27. Now in this case, Section 9 burden is always on the petitioner to prove it. So he has, petitioner is not only required to plead it, but also to adduce evidence. And the purpose of cross-examination is well known. It is only to impeach the credibility. Now in the cross-examination, if an adverse name comes, which is not introduced in the evidence in chief, can you still say that the evidence remains unimpeached? Now you see what happens is that we are dealing with many cases in civil side also. Yeah. Like you see, for example, somebody comes, gives an evidence of that he's the owner of land measuring 1 bigha covered by pata number 1, dag number 1, or village number 1, so and so, moza so and so. And the cross-examination, somebody asks him, what is the dag and pata number of his land? He says that I don't know. I can't remember. Or he says dag number 2, pata number 2, or village number 2, so and so. Then what would be your reaction as to whether the evidence is unimpeached or it is impeached?
But my thing is that some doubt will be created, but it will not.
No.
My entire evidence would not.
No, you see,
may not
you
fall.
see the principle under Section 3 of the Evidence Act. Is the interpretation clause. In the interpretation clause, there is one there are words, facts in issue.
Yes.
So the facts in issue will always be issue of citizenship, correct?
Yes.
Name of the person's father or mother is not a fact in issue. Now, therefore, when you come to the next words, that is proved, disproved, or not proved, that will always relate to the fact in issue. Then section 4, may presume, shall presume, and conclusive proof. So therefore, you see evidence is given only with respect to the fact in issue. Now, to disprove the fact in issue, if I ask a question and the person can't say the name of his father or mother, can you say that the fact is conclusively proved that he is a father of so and so? Here, the one of the issue would be that whether the proceedee is the father or daughter
Paternal
of, or
uncle,
daughter
here
of,
paternal uncle.
no, that's okay, of a father who is a citizen of India. Now, to disprove the father, that he is the legatee of that father, you ask the name of the uncle and aunt, then you can't say anything. In Mohammedan, it will be more disbelieved, more than a Hindu. You see, because every Sabe Barat, they have to go to the graveyard and pray. So they'll be praying for whom?
All those who have passed away.
So if it does not even know his uncle and aunt, for whom he is going and praying?
But if out of 5 paternal uncles, only one mistake is there.
No, we understand.
And moreover, Lordship would see the names. Lordship would see, if Lordship sees the names in page 21, everyone is Lal Mia, Tara Mia, Sultan Mia, Abdul Khalek, and Dogu Mia, Lordship. So therefore,
No, you
in
see,
the
that is
sequence, she
no,
have
no,
said that.
that is the prerogative of the parents. Correct. I have one of my relatives whom the parents very very lovingly gave them names of eatables. I won't say the name, but somebody is called Rasgulla. That is because in the childhood, maybe the boy was very loving and then plump. So people called him that, and now, even now, we tease him with that name. There are a few nicknames which even your friends would be having. You may not know the correct name of your friend, but you may be remembering them by.
Many times it happens.
May it happens, but then he will say in your evidence that his name is so and so. In the name evidence, you give another name A. In cross examination, B can't be there. You know, yesterday was the exams. Now
Internet
there is a story of one boy coming out of the examination hall and said, "Ah, well, I lost. I had a puria for the question difference between so and so, but the question which came was distinguish between so and so, and I could not use that puria." Yes, Mr. Sharma.
Yes, Lordship. There is nothing, my lord, to establish this link, Lordship, as well as Amida Khatun's to establish Amida Khatun's link with his projected father, Lordship. In 1966, voter list Lordship of different village Lordship, Sohoria Palm, 1965, where Abdul Khalek's name
Yes,
is
Lord.
appearing, Lordship.
Can you just for a moment pass me the
Yes, Lordship.
the records just for a moment?
Yes. After 1965 and 1970, Lordship, suddenly 1997 voter list appearing, Lordship, of different village, Lordship, and Gaubra, although he submitted, placed some certificate of Gaubra, that was not proof, Lordship. Even Lordship, that certificate was not admissible in evidence because of embossing in the.
Just a moment.
Yes,
Let's
Lordship.
we're just looking at one.
from Sohoria Palm Lordship. After marriage, she came to Kolmobari. Born in Sohoria Palm, but after marriage, Sohabuddin was in Kolmobari. সব কি তেতিয়া নামবিলাক বেলেগ আছে মাকৰ হাতীটো লাগিছে মাকৰ হাতীটো লাগিব Abdul Khalik. Both cases are decided together, therefore there is. My name is my father's name is Abdul Khalik.
Mr. Saikia, since you are present, I'm just trying to ask you a question, or rather interacting with you on a matter. You see, in this foreigners cases, now we are getting those land documents by way of e-Jamabandi through the website. Earlier, when we used to have physical copies of Jamabandi, then the year of the Jamabandi used to be written. Jamabandi of the year 1960-61 or Jamabandi of the year 1971-72. So therefore, the first entry, supposing there's a land which is in the name of A, in the handwritten Jamabandi, we used to get the year of Jamabandi, and therefore we could understand that the first entry in the name of the landowner by way of settlement or whatever, that what you call what is settlement operation, or by
That transfer also.
by grant, was in the year 1970-71. But under the present system, we don't get the year of the Jamabandi, and therefore the first entry came on which year, we can't say. Therefore, let us assume that A wants to use the land documents for the purpose of foreigners cases, but he'll have no way to get the reference to the original entry made. So either it'll make the because it for a citizen, it becomes very difficult to get the original entry, because I may not know.
They will get the present status.
He'll get the present status. So just trying to
Yes.
make you aware of the
this kind
things.
of cases, that is very relevant.
No, even otherwise, you see, supposing you are holding a land in your ancestral village, maybe that land has been encroached. Now somebody will say 12 years encroachment, and therefore your entry is prior in point of time, and then there are other land documents to show that you are in continuous occupation or intermittent occupation. Those things are lost when the original entry of the names are not available. I'm just giving you a food for thought. I'm not saying anything.
And
Because
also,
we have
the
not
work
passed
to
any
the
judicial order.
departmental office.
We have not passed a judicial order. I'm just giving you a food for thought, but wherever you deem appropriate, just try to. We adjourn the matter today. We'll take up some other day, because we'll take up a matter of the Advocate General. We list it next week. All sides are represented. The submissions of both sides could not be concluded. We'll stop list again on, give a date next week.
6/11.
Deep blue.
Supplementary list item 41 upgraded.
Please, Manoj, I appear for the petition. On the last occasion, as I recollect, I had argued for quite some time and completed my arguments. After which, my lord, the learned Advocate General argued for some time. And then the learned Advocate General asked for permission to file an affidavit, which he has filed, the counter affidavit. I've read that counter affidavit, my lord, and there is nothing new in that at all. And it relies on the same documents which I relied upon when I argued the matter comprehensively. Therefore, if the Advocate General wants to argue a bit more, and then I'll take a 15-minute rejoinder, that's it.
Okay.
I want to get one clarification from the learned counsel, whether he will rely upon his that argument or he want to add further?
Rejoinder
A
argument is,
rejoinder argument, I have no issues,
Ah.
but he will rely upon whatever he has argued as his first charge.
that's what he's saying.
Fine.
Yes, Mr.
Yeah. So, Lordship, this is a criminal petition where there is a prayer for habeas corpus. So my submission would be, Lordship, at the time when the case writ petition was filed, the bodies were lying in the morgue of Silchar Medical College, and there was a stand taken by the petitioner's family that they will not take back the dead bodies immediately, and they want this honorable court's interference. Pursuant thereto, Lordship, we have filed affidavit, we have filed a postmortem report also. And finally, they were happy, seems to be happy with the postmortem reports, although they made substantial argument on the findings of the postmortem report, whatever the doctor has written. And the dead bodies were taken back. We have handed them over, and they were honorably cremated also, or maybe buried. So now, before going to the facts, Lordship, I would like to place what was the situation developing in that area. This incident happened sometime in the month of August, if I'm not wrong, Lordship. July. But prior to July, what exactly was happening in that area, that Lordship will kindly take my affidavit. Page 239. And the relevant paragraph in the pleadings, Lordship will find that in page
Just a moment.
175, paragraph 10.
For the other learned counsel for the division bench matters, we may not have time to take up any other division bench matters. Because the bench is for a limited
Yes,
time today.
345, if I'm not wrong.
No, I'm just telling them so that they can be free. Yes.
So Lordship will kindly come to page 175, paragraph 10.
Paragraph
10. Because there are certain annexers which like to place before this honorable court how the situation was developing in that Barak Valley area, more particularly Kachar district, bordering Manipur. The deponent further respectfully states that before the incident on 12
Just a moment, my brothers.
I'm sorry.
The document is, the pages are not marked.
I'm not going to the document straight up, but I'm going to the affidavit.
The affidavit itself is not
Okay.
numbered, so I'm just trying to find
If
it.
internal regular pages, I mean the seriatim it is 175. Internal page 9, huh? Affidavit was filed on 18th of September.
Yes.
The deponent further respectfully states that before the incident on 12/7/2024, an information regarding firing by some unknown Kuki Mar militants at about 2300 hours on 11th July 2024 at Chekar Cham under the jurisdiction of Kachudaram police station was received. Accordingly, police team from Kachudaram police station visited the place of occurrence and recovered 3 rounds of empty cartridges suspected to be fired from the AK series rifle. Later on, senior police officials, DIG Southern Range, Silchar, also visited the place of occurrence. I'll go to the annexes little later. Further, prior to that, on 6th of June 2024, information received that one Manipuri Meitei businessman, namely Sobat Sarat Kumar Sinha, son of so-and-so, was kidnapped and brutally killed by Kukimar militants at Jiribam, Manipur. Now, see, Jiribam, Manipur, that is a border place near this Kachar district and Manipur. And suddenly, communal tension flared up in our neighboring district, in the neighboring district of Jiribam and Tamenklang, Manipur, and many families, including
women and children sneaked into Lakhipur subdivision area, apprehending imminent threat to their lives, crossing the Jiri River during the night hours and taking shelter in the community centers as well as in the houses of their relatives. Since then, several violent attacks have been made by armed Kuki Mar militants at Jiriba, Manipur on the security forces as well as
Just a moment, Mr. Saikia.
Lordship.
Has your inquiry concluded?
In
The
2 or 3 days, the report will be submitted.
in 2 or 3 days.
In 2 or 3 days.
Just a moment.
The magisterial inquiry.
Mr. Gonzalez. And Mr.
The
Saikia.
report is ready. In fact,
It's
report has
okay.
been submitted.
I'm addressing both of you.
Yes.
We are of the privacy view that if you are filing, if your reports would be submitted in a day or two,
Yes, Lordship.
we take it up next week because without that, will not be in a, because we'll have to decide 2 things here. Number one, about whether the inquiry should be, it can be accepted or it can be given to another agency. That is one part of it. Second part of it is that even the state, instead of giving it to some other agency, can the state be still given further investigation? That would be a corollary. Second is about compensation. That is an integral part because
Yes.
even under the state notifications, you have a compensation scale.
Lords.
So the point is whether some part of compensation can be given now, part of compensation, or we postpone that. That is one aspect we'll have to take care of.
Lordship.
So in the fitness of things, if you both agree and taking you from your submissions that will be in a day or two, can we take it up next Tuesday? Mr. Gonzalez?
As per
Yes,
your
sir.
lordship's convenience, my lord. Whatever you say is all right.
Instead of Tuesday, Thursday will be
Thursday.
Next Thursday.
Can
Instead of 5th, it can be 7th.
Okay, just we'll
Yes.
deliberate. Just
Wanted to have this one for us. But I have good part. So, তুমি কইটা battery করিল বা 921
no, there is again a difficulty. The roster is now available. One of us will not be there for next 2 weeks.
Okay.
So then the continuity of argument would be lost. Mr. Gonzalez.
No,
let
I
this-
accept it, my lord.
So,
Whatever is convenient to your lordship, please.
so after 2 weeks then.
No difficulty.
Otherwise, we can't, the matter cannot be heard by 2 different bench.
Yes,
Will
It's a
be-
part heard matter. Maybe not, but Lords, the others
Technically-
had already completed.
Technically, we
their-
have not kept it parted, but there'll be a missing in continuity.
Right, Lords.
So we'll just come back.
Yes.
Then 19th or 21st of November, what would be inconvenience, Mr. Gonzalez, you and Mr. Saikia?
19th would be better for me.
19th.
19th.
Yes,
For me too.
Okay. And Mr. Saikia, can some part of the compensation be paid now?
Let it be taken up that time, Lordship. Had it been a normal citizen, Lordship, I would have agreed. But these are hardcore extremists. I do
No,
not
whatever,
agree.
but
Lord.
You have your own.
From my side, no, Lordship. These are hardcore extremists.
Okay.
They were killing people
Then we,
there.
then we put that in the order so that on the next date we can. at least-
Lordship may take this finally disposed of.
No,
way,
finally
that
disposal,
way.
we don't know. Both of
yes,
you are,
I
both of
agree
you
with
are-
that one thing, my lord.
both of you
Lord,
are
I've
astute
argued
counsel.
finally, I don't.
These
have
are
any
not
opposition.
these are not residents of Assam also.
No, that is okay.
They came with AK-47, killing people here and got killed themselves. Why the state of Assam will play
No, that is okay.
compensation?
That is okay. But to conclude the argument,
Had it been for the police persons who died
no,
near
I am on different thing.
Lordship.
I am saying both of you are astute lawyers. By tomorrow, whether we'll be able to complete it, we don't know.
No, I will not take much time, Lordship.
15
other
minutes. My rejoinder 15 minutes, Manoj, by the clock.
That's
I
okay.
saw his affidavit. Completely, I'm ready, 15 minutes.
Okay. Mr. Colin Gonzalez, done as senior counsel, is present through video conferencing, assisted by Mrs. D. Ghosh, learned counsel. In course of his submissions, Mr. D. Saikia, learned advocate general, assisted by Mr. D. Nath, learned senior government advocate, has submitted that as per his instructions received, the report of the ministerial inquiry is likely to be submitted in course of this week. Full stop. Next para. In the event the report of the ministerial inquiry is submitted, let the same be brought on record by way of an affidavit with advance copy to the other side. Next para. Accordingly, the matter stands adjourned today. Next para, as agreed by both sides, list on 19/11/2024. First of both sides will also make an endeavor to make their respective submissions on the issue of payment of interim compensation. Next para. List on 19/11/2024.
Request, my lord, from my side. Since the report will be ready in a couple of days, as the learned advocate general has said, I may be given a copy within a week's time, much before the next date.
We have said, make it as early as possible.
Early as possible.
Because
Faithful.
he's out of station, he'll take some time to get back.
Great.
Highly obliged.
Okay, since we won't have time, we'll rise 5 minutes early, because in 5 minutes will not be able to dispose of any matter. All these motion matters which are left out will be listed by the court master in course of a few days. Give him some time, he'll do it.
And 2 is a connected writ petition, my lord. With the consent of the other side, I've sought for adjournment. Another matter is there, WPC 5560 of 2023, which needs to be connected. One matter has come, the other has not come. My lord.
Why connecting of the petition is required?
This is because they had taken a stand that they would his name was struck off because he said, in my wife's property, I have no claim. In review, he claims that no, I have a claim, it was wrongly submitted or wrongly placed whatsoever, and that the direction was issued to an authority which ought to have been another authority. We brought on record documents to show that in a subsequent writ petition pleadings were there where they had acted otherwise. And the very authorities who were there had acted against us and had not apprised the Honorable Court about the correct developments whereby contempt and other cases were closed. So we had prayed for drawing up a suo motu contempt. Accordingly, Lordship was pleased to connect both the matters together. There was one more matter filed by his son, wherein I was there, but I was not arrayed as a party. But all these things were there, but there's massive suppression that in another case where they sought to be impleaded. This Honorable Court held that no. So far as Gobindo Dev is concerned, you need not be impleaded until the review is done. So they are doing all these things. So
No,
therefore,
there's an issue why I'm
My
asking
lord.
that. You see, in the review jurisdiction
very narrow,
is very narrow.
very narrow.
So why we should call for the records and tag it here?
The other day when we had pointed out these things, my lord was pleased to tag this writ petition.
No, this way, you see.
That's why.
The tagging of this writ petition can be altered.
Not
You
very
see,
well,
because you see the copies of the writ petition
my lord.
will permit you to bring on record the pleadings in the review petition, which is to demonstrate your stand.
So
But
far as
to
my
tag
stand
it-
is concerned, I need to read so far as his review is
I'm
concerned.
not on that. You see, the anxiety of the court is that this is not a regular bench, which is taking up a writ
Correct.
petition.
My-
And therefore, even if I tag the writ petition, the adjudication of writ petition gets delayed.
That's delayed.
So
Yes,
therefore, that is not neither in the
I
your
suffer.
interest nor in the interest of Mr.
Correct.
Ghosh.
And
So what I'm saying is that instead of tagging this, whatever is relevant for you to be placed can be brought by way of an affidavit,
very well,
so that
very well.
the adjudication of these writ petitions are not delayed.
Absolutely, very well.
Correct.
So Lordship may post it up.
Apart from that, my lord, the writ petition which he is claiming that it is connected, it is subsequent cause of action, all this is
No,
subsequent.
whatever
We
is
will
there.
address it when
You
I
see,
review.
whatever is there,
With respect to review, it is with respect to only order passed by
no,
this
that is
honorable
okay.
court.
But you
Not-
see, but if somebody wants to bring on record a subsequent development, we can't stop it. Although we in the review jurisdiction,
It is
the
very
scope
limited,
is very limited.
Very limited.
So it's not that we
So
are not
taking all
conscious.
These things, the purpose will not be served.
was a
with
order
respect to
We
in
review.
the party
don't
order.
know. We don't know. But if there's a litigation which has, which is like a Medusa's head, we think it appropriate that the entire head be there together. So we permit you to bring on, both of you to bring on record
Absolutely.
any document relating to WPC 7620 of 2023 and WPC
5560
60 of
2023,
2023
my lord,
on record.
on record. Sometime in the end of November.
I have not filed 7620.
He has not filed. His son has filed by changing counsel.
We are not on that. But if somebody wants to rely on any other affidavit, we can't stop him. The only anxiety of the court is that we do not want to keep
Absolutely.
adjudication of writ petition pending,
Very well.
because this in review jurisdiction, I can't
Enlarge
stop the adjudication,
Correct,
Yes.
correct,
stop the adjudication of the two writ petition before the appropriate bench.
correct.
I'm not assigned to do that.
Yes.
So therefore, that is the only anxiety.
Absolutely.
Since you have already made a prayer for that, I did a rethinking, notwithstanding that previously 7620 was tagged.
Absolutely.
7620 was filed by him.
Correct,
However,
Filed by
we are releasing it from the, it will not be tagged with the
Lordship.
Yes.
review petition, and
Lordship.
therefore, to give you a window, both sides,
Both sides.
if you want to refer, you do it by way of an
We will file.
additional affidavit.
We'll file. In fact, today we are,
Mr. S.K. Ghosh, learned counsel for the review petitioner the review petitioner is present. Mr. S. Banik, learned counsel for the respondent, has submitted that by order passed earlier, the records of WPC 7620 of 2023 has been tagged with this review petition. And he has further prayed that the records of another writ petition being WPC 5560 of 2023 be also tagged as it relates to the same subject matter. Next paragraph. As only the review petition is tagged with this bench, and this is not a regular bench taking up the adjudication of writ petitions. comma, by tagging the two writ petitions with this review petition, comma, the adjudication of those two writ petition would be delayed. Full stop. The same is not in the interest of justice. Next para, accordingly, we direct that the records of WPC 7620 of 2023 be de-tagged. Full stop. Both sides are granted liberty to bring on record any matter and any matter relating to the readings or documents appended. The readings or documents filed in connection with WPC 7620 of 2023 and WPC 5560 of 2023 on record by way of an affidavit. Next para. The registry shall detect WPC 7620 of 2023. Next para. As agreed to by both sides, list the matter on.
Sometime in the end of November, Milord, we'll file the affidavit from Kachari has to come.
My lord, issue is very simple.
No, no,
So
I
we
am
need to
prepared
file on it, please. on
No,
it.
no.
I am
re-
prepared
review,
to,
my lord.
I am prepared to hear the matter,
Review
but you
is
tell us the date.
only small point.
November
of
last
all in
I am
this
not
case.
saying.
30th November.
Regarding
Mr.
filing of
Ghosh,
affidavit, he has
Mr. Ghosh,
earlier also
Mr.
given
Ghosh, please
sufficient
try to
opportunity.
understand. I am not afraid with the volume. Correct. So please tell us a date. It's convenient to both of you. We'll take it up
November
on that
30th.
day.
Milord.
Volume is not a question.
It won't be voluminous also.
No, no, let
Very
it be whatever voluminous.
It would not
But
be.
the volume which I have handled, maybe
No,
you have not.
I am not saying that volume regarding
Please,
volume. I am saying that
30th
earlier
November,
also
Milord,
he has
30.
taken time.
You tell a date. He's asking for 30 November. You agree to that date or
I
not?
have no objection.
Obliged.
30/11/2024. 30.
30.
30 is a Saturday.
I'm sorry. Milord. Stand
You
corrected.
want to come on that day? You
No, it
give an
was-
undertaking.
It shows it's an open day. Milord. I was the 2nd December.
No, make it November only. Don't
29th?
make it. Not 29th Friday. Make it 28th.
28.
28 November 2024. Yes.
Obliged.
Item 3
Achha, just a moment. Being on record, at least 1 week prior to the next digital listing. At least 1 week prior to the next digital listing.
Yes, yes, yes.
Oh, you are there. Okay. Oh, okay. Achha, you also say there, Mr. D. Nath, the senior committee advocate, appearing for respondent number 4 in WPC 7620 of 2023 is present. Achha, Mr. Farid is also there. Mr. Mohammed MD F. Faridi for respondent number 3 and 5 is also present.
Ian?
Item 3
My lord, 5 in the repetition 5 is not effective. 5 I am. Ravindra Chandra Dev. Oh, yes.
He's in item 2.
Have you applied for the exit poll?
Item 3
Yeah, please, Your Lordship. This IA we have filed subsequent to a judgment and order, Your Lordship. The Lordship will kindly take up page 11 of the IA. This is the Dibru Dangari matter, Your Lordship, had there were 3 writ petitions. The relevant 6/2/43/23.
Extra copy.
The relevant,
Just a moment.
sure, Lordship.
Yes.
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 Lordship, this was a common judgment and order, Your Lordship, and the relevant page, Your Lordship, at page 25, Your Lordship,
25.
25 of the IA.
Yes.
If I may just read para 11. Therefore, the court is of the considered opinion that as the BOD of DDR PMSS Limited stands dissolved on and from 39/23 by operation of section 39 of the 2000 Act, all these three writ petitions have become infructuous and need not be answered and not be decided. Para 12, Your Lordship. Accordingly, it would be open to the Registrar of Cooperative Societies Assam and oblique or its other authorities like the Assistant Registrar of Cooperative Society Tinsukia to pass such appropriate order or orders as it may deem fit and proper to ensure proper management of the affairs of Dibru-Dangari River Part 1 means Samarbaya Samiti Limited till a fresh board of directors of the society is constituted.
Oh, you want extension of time?
Lordship, I am seeking extension of time.
How much time?
Lordship, I am seeking further 3 months' time here.
Why so much of time?
No, I am seeking your Lordship. Earlier, what has happened, your Lordship, that Lordship had
No,
granted
because-
3 months' time.
No, Mr. Raskwa,
Yes, your Lordship.
in fish, I think, since I am not a fish eater,
Lordship.
I see fishy in every fish.
No, but
So
this
why-
is within the cooperative, but if my lord allows it, then my review becomes infructuous.
What is the review?
Review says, my lord was pleased to dismiss two writ petitions, basically. A and B, one filed by my colleague Miller and one by me, whereby two AGMs were cancelled. On the ground that compliance of section 43(8) of the act, where government needs to be served a copy, government nominee is there, was not compliant. On that, they readily, neither my colleague nor I nor them, no one could address. Anyways, subsequently, we got hold of a document whereby we had approached the authorities well prior in point of time. And that we went in appeal. In appeal, it figured out, he also objected that should always apprise the honorable single judge. Therefore, taking the leave from the division bench, we filed the review. For your lordship consideration, if this is compliance of 43(8). If this is in compliance of 43(8), then our AGM will hold good. In that point, there is no requirement of any subsequent extension of time.
If the flood situation had not happened, probably the election would have already happened, your
But
Lordship.
they filed it
So if
way too late.
On the 45 days, your Lordship, we have filed earlier, your
Now,
Lordship.
if my lord allows it, it
Prior-
becomes,
prior to
my appeal
the
becomes,
vacation,
my review becomes infructuous. my lord.
That's all,
Yes.
no? Assam Fishery Rules.
No. The Cooperative Society Act.
Cooperative Societies Act. Okay, that
I can,
Cooperative Societies Act. Okay. Cooperative Society. Assam. Don't go. It's done, direct. Let's just take it, Daniel, take it from him. Take a copy.
Got
could you buy 43?
3.
Yeah. I'm referring to 43(8). It possibly would be at page 41. May I read? The state government and registrar may appoint nominee to the board or any subcommittee of a cooperative society on its own motion when the government have subscribed more than 50% of the paid up share capital or when there is provision of government nominee in its bylaws. The reference to this provision in my review would be at page 25 in the order. Under review, in the order under review. Page 25 in my lordship is there. That will be
25.
25 of the review petition.
Yes.
That's internally page 13 of the order. Mine is referred to that. May I read?
So what will be the effect if you give a notice to the
Then the ground on which my AGM was cancelled, that we had not given notice, would perhaps be reviewed. That was not readily available then. And of course, they also received notice, he also did not know.
And
That's
that-
only one.
That notice was not submitted to us at that point of time.
That's why I'm
There was
taking a
some
notice.
letter which was 3-4 months prior to the.
Correct, my lord.
Prior to the decision.
So what
taking in
notice
area.
was there?
Where is that?
Absolutely, my lord.
Where is-
My lord, finds at page 29, the first one, 31, the second one, 29. May I read 29 minutes? Lordship is there. 29. Most respectfully and in connection with appointment of government nominee. That's dated 26/6/2023, way prior. Most respectfully, it is stated that our society is a registered fishery cooperative society. Presently, Brahmaputra Part 1 and Dibang River fishery has been settled by the Fishery Department of the Government of Assam with a society. No government nominee has been appointed presently in our society from the department. As such, our society is facing problems in management and business, etc. For proper management of our society, an official from the Office of the Assistant Registrar of Cooperative Societies may appoint a government member in a society, and this is a humble prayer. We had done this in 26th of June. Now, my lord, on page 31. This is a communication from the Office of the Additional Registrar of Societies, my lord, from Guwahati, addressed to the ARCS Tinsukia. This is, my lord, with reference subject above and in enclosing 2 pair petition under reference. I am to request to take action as per so and so, sir. My lord, this is where we stand. What we have stated is that, so the government may appoint a nominee, the government may not appoint a nominee. The point is, on this point, we had a communication way back prior. This could not be brought on record. Now, if Lordship holds that this is in compliance with 43(8), that we have requested for a nominee, then yes, if otherwise it's not. That's the short point, Miller.
Mr. Rasko, you obtain instruction and tell us we are taking it up next week.
Lordship.
If you have received this communication
He's not denying that.
and page 31, if it is in that context,
Lordship.
then we'll take a call on the next thing.
No, he is accepting it, Miller. His submission is only that.
I need to take
no,
instruction.
this is
Your
a review
Lordship, because
petition.
this
We have not
is-
issued a
this has
notice.
come subsequently. This
We have
was
not
the-
issued a notice.
Lordship.
We'll ask him to get instructions and tell us.
Very well.
Because
It should not be from Mr. Rasko, it should be from the.
No, they objected in the rate appeal
No,
also.
that's okay.
I very well.
But they'll have to, it will be the stand of Mr.
Okay,
Rasko
correct,
through
correct,
the
correct.
respondents.
And so far as his IA is concerned, Miller, that
See-
also may be, because if it is allowed now, my
Next
case
week,
goes.
You're taking up next week.
And so far as my friend, Mr. Kalita is there, he is representing the other writ petitioner, they have surrendered, accepted the faith. But of course, he is there. They don't have such document, Miller.
You're following which state module now?
I could not get it, Miller. Sorry.
In this political scenario,
I get it.
which state module you are following?
Nothing.
No.
One of us we sailed from. Now we are in good terms, therefore he is not objecting to it.
That's why
That's why.
this is the only forum where we can ask political questions. So I'm asking which state module you are following.
I keep it to the brief.
In this review petition, you say. Heard Mr. Asbani Leonard, counsel for the petitioner, as well as Mr. V. Rajput, Leonard counsel for the petitioner and the standing counsel for the Corporation Department.
He's 1,
Presenting-
2, and 3.
Respondent numbers 1, 2, and 3.
And he's for 4. You can just.
And for 4, Mr. Kalita is there. As well as Mr. N.K. Kalita, Leonard counsel for respondent number 4. Next paragraph. The learned counsel for the petitioner has submitted that this review petition is listed together with IA Civil 2965 of 2024. And it is submitted that if the prayer made in the said interlocutory application is allowed, there is every likelihood that the review petition would be rendered infructuous. So accordingly, next para, accordingly, both sides express some urgency in the matter. Next para, issue notice returnable on is returnable on the
5 তাৰিখৰ বাহিৰে চবে পাৰি।
okay 7/11/2024. Requisite extra copies of the writ petition or the review petition is served on the learned standing counsel for the Cooperation Department in course of the day. Next para, in view of the stand taken by the learned counsel for the petitioner, the registrar of cooperative societies as Assam shall ensure that their instructions are conveyed to the learned standing counsel for the Cooperation Department within time. Next para, list on 7/11/2024. And then IA civil, you write. This order will be in 163 as well as in 140.
Correct.
Same order.
order.
Same order in 140 also. So correct. Then IA civil 2965 of 2024. Just say that Mr. V. Rajput and standing counsel for the petitioner. So make it applicant. Applicant submits that in terms of order, judgment and order dated 30/4/2024, passed in WPC 6243 of 2023 and connected cases. Comma, a direction was issued in paragraph 13 thereof that the new board of directors shall be constituted preferably within a period of 3 months from the date of communication of the certified copy of the order. Full stop. It is submitted that due to reasons more fully explained in the application, comma, the new set of board of directors could not be appointed within the time allowed. Accordingly, comma, by filing this interlocutory application, comma, the applicant is seeking extension of time to comply with the order of the court. Stop. Pays for 3 more months' time.
Lordship, it can be 45 days, your lordship. When I meant 3 months, it can be 45 days, or within 45 extension of.
Achha, now 45 days.
45, now 45.
Now, 3 months within bracket, now 45 days.
Yes.
Since the application was filed on 18/9/2024, bracket closed. Next, Mr. S. Banik, learned counsel for the respondent number 1, submits that against the said judgment and order referred above, comma, the respondent has filed 2 review petitions, being review petition 163 of 2024 and review petition number 140 of 2024.
No, one is gone. That we had filed without making him a party. We subsequently withdrawn that to the liberty and therefore this is filed.
Okay, 140 is gone.
Gone.
So then 140 don't pass an. No, I told him to pass an order in 140.
No,
That's
I
why.
thought it was in his case number, IA
No,
number.
no.
And that is gone.
140 is not there. Has filed review petition in 160 of 2024. So he submits that the said review petition will become infructuous if the prayer made in this interlocutory application is allowed. next para. Accordingly, this is the matter along with review petition 160 of 2024 on 7/11/2024.
Yes.
Yeah. এইটো উঠাই দিব পুলিচ মেনেল এইটো উঠাই দিব